as Judge Robert Birch used to tell me in cases like this, why don't I just put them in adjoining cells up there on the hill? Let them work it out between them.
Well, Judge,
rather than spend all of this time that we've spent over because they both want to have their pound of flesh.
Hey there, welcome to the Courtroom Files. So today we're adding a new judge to the channel. This is Judge David Wolfe. He is from Tennessee. He works in several different counties doing a lot of different things. He's a busy guy. If you want to see everything he does, we put a bio in all of these judges' playlists, so you can find it there if you go to the channel page. Anyways, this is a family matter that he is hearing today. It's a divorced couple. They have a 4-year-old child. The father is upset because the mother enrolled the child in preschool. The mother is upset because dad has a child support issue, but it doesn't stop there. They can't get along, so they've had a guardian ad litem that's been added to their case. Again, this child is 4 years old, but they got divorced about 4 years ago, so sometime around the time she was born, so this is all this child has ever known. And we find out in this hearing that the child is actually in counseling already at age 4. So there's a ton going on. This is a longer video, but I encourage you to watch it for a couple reasons. First off, we're going to be Switzerland on this and not share our opinions, but it is hard not to form an opinion of both of these parents as you watch. So from that standpoint, it's interesting and worth your time. But as well, at the end, I want you to be able to hear from the judge and his thoughts on the whole matter. You'll find, if you watch Judge Wolfe enough, and we're going to add more videos for him, that he's fairly even keel and thoughtful, but it's also very clear who's in charge of his courtroom, and he makes it very clear what he thinks of things. So let us know in the comments your thoughts on this couple and this hearing. Let us know what you think of this judge, because we kind of like him. It's, again, just a different aspect of court. And put a like on the video if you enjoy it. Subscribe to the channel if you haven't already, and let's roll the game film.
Is this Ashley Candace Brooks Wilson versus Robert Edmund Wilson? Is that correct?
Yes, Your Honor, I have a motion for consent.
All right. Either side wish to make an opening statement?
Yes, Your Honor, if you could, if you could see, it's contained in the body of my motion. These parties were divorced back in, I believe, in 2020, and a parenting plan was established for their one daughter. At the time, Your Honor, you heard this case back in 2020, and you specifically ruled that the parties had joint decision-making, including that on educational decisions, and there was not a default, if you would. There wasn't a veto power, as we sometimes call it. And so, again, this child is 4 years of age. She will be 5, I believe, in December, so she's not of mandatory school age at this point in time. On May 31st of this year, Mrs. Brooks, the mother of the child, sent a text message to my client stating that she is, again, Mrs. Brooks is a teacher with Montgomery County, and she works out of the Montgomery Central School Building. And she texted my client on, excuse me, Your Honor, May 31st, stating that their daughter could be involved in a peer program through a pre-kindergarten program at her school, and that she went on and signed her up to save her spot, and it sent my client a note saying it would be $200, I believe, a month for her to go. My client did not agree with that. She unilaterally enrolled the child in school and began the child going there, and she made a unilateral decision. My client has midweek visitation during the day. He works from home, and he arranged his schedule to where he had the child during the day. And she decided to enroll this child only after we filed a petition to modify the residential schedule. And she did that in violation of the decision-making provisions. And we're asking that she be held. Again, Your Honor, this is one of those hybrid type scenarios that we ask that she be held in criminal contempt, because it's one where she doesn't hold the keys to the jail cell, so to speak. And again, other than Your Honor could, I guess, say it's civil and give her an opportunity to remove the child from school. But again, it's a scenario where this is one of those that they should have made a joint decision. He should have been involved in the process, and she did not allow him to do so. Removing the child from school, I would much rather she be found in criminal contempt for doing it. And whether Your Honor reserves punishment after a final hearing in this matter would be appropriate, but we do elect to proceed on criminal contempt.
Right, Mr. Spratt, they are proceeding on criminal contempt.
So have a motion for contempt pending as to Mr. Wilson's child support. He has made a payment by a cashier's check. So without knowing exactly what happened there, we would also elect to proceed under criminal contempt. The civil contempt keys to the jail, that purge would be satisfied at this point. As for Ms. Roberts' motion, I have filed a response to that showing where Ms. Wilson emailed Mr. Wilson regarding this way back in June. And he had, from the face of these emails, he had deferred the decision to the guardian ad litem, Ms. Coffinberry. There, I believe, were some more conversations about this where he never voiced any negative. He never voiced that he didn't want the child to be enrolled in a pre-K program. Further, in the current permanent parenting plan, the child was vested with a right, as it's stated in my response, to go to school where the mother works, which is in Montgomery County. The GAL on this email chain, which is attached to the response, said this is a parenting decision, which ordinarily is correct, but in so much as he has deferred to the GAL, she would support the pre-K enrollment. Mr. Wilson's.
Your Honor, again, I'm going to object and again caution the fact that my client is not
There's an
didn't say-
objection to you referencing any sort of statement from a counselor.
I didn't reference the counselor. No. I referenced the GAL. No, I referenced the GAL saying that she supported the decision in so much. It was a parenting decision, but in so much as the father had deferred to her, she supported the pre-K enrollment. So I don't think facially that there's been any order violated directly here. So, and I do believe that Mr. Wilson has sat on his rights and deferred to the GAL in that regard, and that's stated in my response.
All right. Ms. Roberts, you may call your first witness.
Your Honor, I would Ashley Candace Brooks.
You'll raise your right hand and be placed under oath, please.
State your name, please, ma'am.
Ashley Candace Brooks Wilson.
And Ms. Brooks, where do you reside? And is that located in Dixon County?
Yes, ma'am.
You are a certified teacher and work with the Montgomery County School System, is that correct?
Yes, ma'am.
And what school do you work out of?
Montgomery Central Elementary School.
And what grades do you teach?
I teach third.
And how long have you worked there?
Oh. I have worked for the school system for almost 20 years for that particular school. I believe starting in 2016.
But at the time y'all were divorced, that's where you were working?
Yes, ma'am.
Correct? You have another child?
Yes,
Is that
ma'am.
correct? And how old is that child?
He's 10.
10. And when did he start school?
I cannot recall the year, but he started kindergarten.
He did not go to a pre-K program, correct?
No, ma'am.
And did your mother keep him while you were working?
Yes, ma'am.
And that's the same as your daughter. What is your daughter with Mr. Wilson's name?
Emma Jane?
Emma Jane. And Miss Emma Jane, while you work, your mother typically provides childcare, is that correct?
She did until she had an opportunity to attend pre-K.
I beg pardon?
She did.
Okay. And you understand what type of residential schedule does Mr. Wilson have with Emma Jane?
Well, week 1, he has Monday during the day while I'm at work, Wednesday while I'm at work, Tuesday, the week 2, he has Tuesday overnight through Thursday.
So does he have weekend time too?
Yes, ma'am, every other weekend.
You alternate weekends. And then he has Monday and Wednesday during the day on week 1.
Yes, ma'am.
And do y'all meet to pick up the child, or does he come to your house to pick up the child and you come to end?
So the parenting plan says that he picks her up at 8 o'clock at my mother's house. So that's where he does. And then for the other weeks, he picks her up at my residence.
Your residence? On the weekends?
Yes, and on the weekends.
And so you, on May 31st, did you send a text message to him or some type of written communication expressing that Emma Jane could be involved in a model child in a pre-K program through your school?
I did email him.
Okay. And it would have been, this is explain what kind of program it is where you would say your child would be a model.
So it's a traditional pre-K program with curriculum with the state of Tennessee. I have the curriculum here today printed out so that you can see the standards if you would like to, but it's a daily pre-K program. So
Why in your email did you put that she would be as a model?
So she's a peer model because I don't meet my income exceeds the traditional pre-K standards.
So this is, the program through Montgomery Central is a economic-based program for people of low income.
Well, I believe through all of Tennessee, it's granted first to students.
I'm asking about this program. The program that you wanted to enroll your child in is an economic-based program for lower income individuals.
Not necessarily lower income.
Or certain qualifications.
There are certain qualifications, yes,
You do
ma'am.
not meet those other than the fact that Emma Jane can go as a peer model.
Yes, ma'am.
And what does that peer model mean?
So as a peer model, she's just given the same opportunity as other students to learn, to have that social setting, to grow.
Why would you have said she gets to go as a peer model?
Because just as a traditional student, she wouldn't meet the, the lower income or the.
Special, and again, I know this may not be politically correct, and I apologize, I don't mean this to sound, but special needs, children who need earlier intervention.
Well,
Is that right?
Socioeconomically.
Thank you. I'm sorry, I apologize if it was politically incorrect. I didn't mean it that way, but again, for socioeconomic reasons, that's the children that are typically taken into that program.
They're given priority.
And then she got to go in because she didn't meet those requirements. If she would be her model.
Well, she doesn't meet those requirements, but she is there because they do open up some slots to other students.
And in that email you sent and told him it would be $200 a month?
I notified him of the schedule and the cost, yes, ma'am.
Okay. He never gave his consent.
He did not give his consent or his disapproval.
Well, but you went on and said, I've already done it. I can get, the text message said, she's done it, I've already saved her spot. That's what you sent, correct?
That is what I sent, yes,
And then
ma'am.
that's what your response was, and your attorney filed the response, that you admitted that you did that without his consent. Correct?
Well, I did enroll her and then
You did.
notify of
You
it.
didn't talk to him about it before enrolling her.
Not
correct?
before enrolling her, no, ma'am. I was using what was in our parenting plan, saying that I could enroll her in my school.
But it does not say in your parenting plan that you get to make unilateral decisions about her going to school before mandatory required, does it?
I don't know about mandatory.
Well, you understand the state, you're a teacher, you understand that there's mandatory attendance for certain children. They reach an age, they have to be enrolled in school unless they apply for some exemption, correct?
Can you repeat that?
Homeschool, religious reasons, you gotta go to school in the state of Tennessee, don't you, as a child?
Oh, yes, ma'am.
Okay, and your child's not at that age level yet, correct?
Well, she's at age for a pre-K program. I've had her previously enrolled in the
Not
pre-K
yet.
program.
I apologize, I didn't mean There's no mandatory pre-K program in the state of Tennessee.
Mandatory, not that I know of, but I can't say yes or no either way.
And you enrolled her without consulting, discussing, talking to him about it. You just sent an email, said, I've done it, correct?
Well, I didn't notify him of the other pre-K program that I had her in either. Like, she's been in a pre-K program
So
before.
you're admitting here that you put her in another educational program that you didn't have her permission, his permission?
I'm admitting that she was in a daycare pre-K program setting.
When did you enroll her in another pre-K program, another daycare program? Babysitting, was it a babysitting, work-related daycare, or was it an educational program, ma'am?
I don't know that there's a difference.
Yes, ma'am,
It was a
there is.
daycare program with an educational curriculum that follows the state of Tennessee
When did you
guidelines.
enroll her before you did this?
Guardian Angel, Oak Grove, no, I'm sorry, not Oak Grove, Lone Oak, Guardian Angel.
Where was that?
It's on Highway 48, right near my school. I don't know the exact address.
Did you pay for that?
I did.
Did you notify him that she was going, that Jane was going there?
No, I did not notify him of the daycare program because we
Well-
were on our own for daycare.
Well,
time.
but you testified that your mother's provided daycare.
She did for some, but I really felt like my daughter needed to be in a social setting with peers her age.
But again, that was more of a daycare program while you were working, not pre-K.
Well, it has the same schedule.
And you didn't tell him about that either.
No, ma'am.
You understand that the parenting plan specifically says that y'all make some meetings?
I do, but regarding daycare and the curriculum daycare
I
has,
didn't ask about daycare, ma'am. Did you understand my question?
can you repeat your question?
Did you understand that your parenting states specifically that you and Mr. your daughter,
Yes, ma'am.
and you did not allow him to make a joint decision with that, did you?
I did not deny him the right to make a joint
Did that-
decision.
Did you involve him in the process of selecting? Did you give him the curriculum?
He did not ask for the curriculum.
I didn't ask that, ma'am. It's real simple. My question was very elementary. Did you give him the curriculum for the pre-K program that Emma Jane is enrolled in?
I did not provide him with the curriculum, no, ma'am. It's available online.
Did you give it to him before you enrolled in her?
No, ma'am. I have a copy if you would like it.
Well, if you have a copy and it was so readily available, why did you not discuss it with him and say, hey, Rob, here's the pre-K program that's at my school that I think Emma Jane would benefit for. Here's the curriculum. Let's talk. Would that be difficult for you to do?
No, ma'am. I do believe I
You
did
elected
that.
not to do that, correct?
I did not use those words in my email, no, ma'am.
Well, what words did you use in your email?
I notified him of the program, the schedule, and the costs, and then I waited for his reply.
Emma Jane is eligible to be enrolled in the pre-K program at Montgomery Central as a peer model.
Yes, ma'am.
I've already secured her spot. I've already enrolled her, correct?
Yes, ma'am.
And it costs $200.
Yes, ma'am.
And then you continue to send a request for him to pay for that program.
No, ma'am. I never asked him to pay anything for the program.
You haven't sent him anything asking for payment on that?
No, ma'am. I have never asked him to cover the cost of the program.
Why did you think you had the right to unilaterally enroll your child?
I don't believe I unilaterally enrolled her in there. I don't believe I denied him his right to participate. But because it was in a school system setting versus a independent setting, I just felt that he also needed to know that, hey, she's in this more structured setting.
That's all, Judge.
Mr. Spratt, do you have questions?
Where in your parenting plan that your child has a right to attend school where the mother is teaching? Are you aware of that provision?
Yes, sir. I am aware of that.
Okay. And is she at school where you're teaching?
Yes, sir. She is at
Okay.
school where I'm teaching.
And you sent this email to Mr. Wilson, correct?
Yes, sir.
All right, and his response, what was his response?
His response was that it was, his understanding was it was up to the GAL at that time.
Okay. And did you ultimately reach out to the GAL?
I did, yes, sir.
Okay. And how did that go?
She was in support of her attending school.
And she's quoting who?
Ms. Coffenberry?
Coffenberry. We'll let Ms. Coffenberry speak for herself, unless there's some basis other than it being hearsay.
Well, Judge,
Well, it
what,
becomes an issue of whether it's willful and deliberate and criminal contempt, so overruled.
so did Mr. Wilson ever specifically, you advised him of this, correct?
Yes, sir, I did.
All right, and he never said no, right?
No, he never said anything in response to that email or in conversations we had with the counselor. He never objected to it. And still to this day, except for this motion, I have not heard like an objection to her being enrolled in this program.
He never, did you talk to him about this some during the summer?
We had conversations with her therapist, with Emma Jane's therapist, and he never once spoke out at all about it in my presence, that he did not want her enrolled in this program.
Okay. And was the child would be going to your school next year, right?
Yes, sir.
Under the
Well,
current parenting plan,
yes,
right?
sir.
Okay. And now let me ask you how that's going. Is he taking her to the pre-K?
No, sir. He's not taking her to the pre-K program during his days.
Okay. Is that going to affect her ability to stay enrolled, the absences?
It's not going to affect her enrollment.
Okay. So his parenting time's not being affected?
No, sir, it's not being affected.
Okay. He's just, but did you take that as he deferred his authority in this decision to Ms. Coffenberry?
That is how I took it.
Sustain, restate your question.
Did you understand, how did you understand him responding to you that way?
So when I presented him with the idea that she could attend school, he didn't have a negative response to it. He didn't have I don't think she should be in this program. I didn't have any of that response from him. His response was just that it was up to the GAL.
And when is the first time that you learned that he was against this?
The very first time was when the teacher made calls home. And so she notified him and she just let me know he wasn't in approval of it.
After she was enrolled?
After she was enrolled, yes, sir.
So, and what day was she to begin?
In August, schools officially, I cannot remember the official school start date, but school started in August, about that first or second week of August.
First or second week of August?
Yes, sir.
Okay. So you notified him two months and some change in advance.
Yes, sir.
He defers to the guardian ad litem.
Yes, sir.
You talked to him a little bit more about it during the summer. He never said anything one way or another.
Correct.
Okay.
I told him of the opportunity, and after telling him of her opportunity, he never objected to it personally with me.
Did you willfully try to violate a court order?
No, sir, I did not try to violate a court order willfully.
Okay. What's your reasoning for putting this child into pre-K?
Well, she needs to be in a structured setting with peers her age. Like, I appreciate that she's in a setting with cultural diversity, like racial diversity. Mr. Wilson came to me and told me that there were some troubling things that she was doing as well and saying, and so I really feel like this would support her social emotional learning so that she can see that she has success as a 4-year-old. That's one of the reasons why she was in daycare with, kind of like that structured educational setting too, so that she could be with peers her age.
So to learn and educate
Yes, sir.
about different cultures and just learning in general.
Yes, and like I want her to feel success as a 4-year-old, like so she can see like these are the goals for a 4-year-old, these are the educational standards, these are the behaviors of a 4-year-old. Like I want her to have that success story.
Wow. And that was your reason for doing that?
Yes, sir.
And you got no objection from him?
I received no objection from him whenever I told him of her opportunity to attend.
Okay. Those are my questions.
Ms. Roberts, you have any other questions? Thank you, ma'am. You may step down.
Your Honor, I would call Mr. Wilson.
Wilson, come around, please. Raise your right hand and be placed under oath.
State your name for me, please, sir.
Robert Edmund Wilson.
And Mr. Wilson, where are you currently residing? Okay. And you have a daughter with Miss Brooks Wilson, is that correct?
Yes.
And how old is Miss Emma Jane?
She'll be 5 in December.
Now, you and she, under your parenting plan, what is the decision-making set forth in your parenting plan?
It's supposed to be joint.
On May 31st of this year, did you receive a text or an email communication from your
I did.
ex-wife?
Yes.
And what was that email communication?
That she was enrolled in a pre-K program and listed some other things and was regarding a health concern at the time,
And
minor.
were you just, before you did, was it just informing you that she has enrolled her in a
Yes.
pre-K program
Yes.
at Montgomery County,
Yes.
at the school where she teaches?
Yes.
Okay. You understood that the court ruled at the time that we went through this divorce in 2020.
Sustained, don't leave it with us.
I hadn't finished my question. May I finish it?
You can finish it.
You understand at the time that we did the 2020 that the court made some specific rulings about where your daughter would attend school.
Yes.
Can you tell? I'm not suggesting the answer to the witness, Your Honor.
You're stating a question, making a statement and asking him whether he agrees with it or not.
And
It technically is leading because you're suggesting the answer, does he understand it or does he not? But it doesn't seem to me that there's a whole lot to be gained by having to make you restate it in a non-leading form, so
I
I'm
will
gonna allow-
rephrase the question, Judge. Do you remember what the court ruled in 2020?
Yes, that she would be attending school at Montgomery Central Elementary.
Did you have if it was time for her to attend regular school,
No,
would you have complied with the court order?
I would have at that time. Yes.
Was there any before this email that you received advising you that the child was enrolled in a pre-K program? Was there any discussion, conversation, or anything about her starting attendance at school?
No.
Would you have liked for that to happen?
Not in the current state of things.
Why?
Her mental state was seemingly fragile. She was saying things like.
Okay, don't say what your daughter was saying. There were things
Sorry.
that, did you have an opinion as to whether or not it would have been appropriate for her to start a pre-K program?
I did, yes. I don't think it was appropriate.
Did you discuss that with the mother?
I did not, but I was never given opportunity.
Did you take the opportunity to say, was there ever a discussion about putting her in a pre-K program?
No.
Either by you or by her?
No,
Were you blindsided when you got this email?
yes,
Do you believe that it violated the terms of the parenting plan?
I do.
Sustained.
Has there been other occasions when unilateral decisions have been made?
Many,
Overruled.
Answer the question.
prior to that, when I had set the appointment with her primary care, to get her into a therapy program. At that time, we were given a list of providers in our area, and she had added the one that we wound up going to, but I wasn't part of the decision. I was doing research on all of these facilities and trying to figure out what I thought the best fit would be. And she had already made an appointment with Miss Harrison, and I objected on multiple reasons and provided her with my alternatives, my opinions on where she should be, and there was never any feedback on that other than she intended to keep her appointment with Miss Harrison.
So your daughter did something occur that resulted in you feeling necessary to make an appointment with your daughter's primary care physician?
The statements that she was making were,
And did you notify Miss Brooks Wilson about a doctor's appointment?
yes,
Did y'all both attend that doctor's appointment?
yes.
At that point in time, was there a recommendation?
There were multiple. She added that one to the list because it
Now,
was.
was there a recommendation?
No,
The doctor just said, get out of my office?
she handed us a list of.
Okay, what
Yes.
did I said, was there a recommendation to do something?
Yes, to get her into therapy, sorry.
I'm sorry. The hearsay
Was
hasn't
there-
been introduced at this point. There's no statement being made. It's an anticipatory objection. You're objecting to what might be said were the recommendations, but we haven't reached that point yet.
There was a recommendation. Did you and Miss Brooks Wilson, take what the doctor had told you and take additional steps?
Yes,
Did you have any input on what those additional steps would be?
none at all.
But did you cooperate with getting your child treatment?
Yes,
Then after that happened before this daycare event,
yes,
correct? So after that was done, and then you get notified that a decision had been made to put her in daycare without your input, did you feel necessary to bring this to the court's attention?
I did.
You want to be involved in all the decision-making with your daughter.
I do.
You have visitation, do you? You have residential time, do you not?
Yes, ma'am.
And is your residential time right now during the week?
2 days during week, 1 hour, 8 to 5:30, and Tuesday, 5:30 to Thursday, 5:30 of week 2.
So week 1, you have daytime visitation on 2 days?
Yes, ma'am.
And then you have the weekend?
Yes,
Then the next time you have overnight from Tuesday to Thursday?
yes.
When is the school program?
8 to 3,
On
8
what
to 3 or
days?
3:30, Monday through Friday.
So enrolling this child in a conventional pre-K, Monday through Friday, 8 to 3, so to speak, would interfere with your residential time? Does it interfere with your residential time? Excuse me, I apologize.
Yes,
It's simply foundational, but we can be here all day. So, again, have you unilaterally just not decided not to bring her to the daycare? To the preschool?
I conferred, and it was advised to me that did not have to do that on my parenting
And
time.
that's what she's not going during your
No,
time?
no.
Okay. I didn't,
But I don't think it ever came out. I think he said he conferred and he's not taking the child on his days. And that is what I understand, right? How is that objectionable?
I did.
It doesn't matter who advised him. That was not an inadmissible statement. Overrule your objection.
Now, so it's not interfering with your residential time, correct?
Correct.
Okay. But do you take offense not being able to have joint decision making?
Yes, great offense.
That's all. Thank you, sir.
Are you prosecuting your motion for contempt at the time too? I don't care. I'm just asking whether we're going to have another hearing on your motion for contempt.
I can address that.
All right, thank you.
If you call him and direct examining him.
Well, and that is the reason we're having this discussion. I just don't want to end this thing and then there be some issue. I want to know if either of them have violated a court order, then obviously, and both of you have motions for contempt, let's deal with it. But if you need to do that in a separate, conclude this hearing and then call another hearing, then you can do that. So.
Mr. Wilson, you did send an email on June the 1st saying that you deferred your decision to the guardian ad litem on this,
No, I
right?
stated that it was my understanding that it was her decision and attempted to follow up regarding that.
How did you attempt to follow
I
up?
called her office and attempted to talk to them, but all they said is that they had spoken to the mother.
You didn't call the guardian ad litem?
I called her office. I called back the number that I had spoken to her on previously.
And this was on June the 1st?
No. I believe our phone conversation was a few days after that in June, and I made my objections to this program clear to her at that time,
To who?
Ms. Coffinberry.
You did? Okay. And you called her office and spoke to her?
We had the initial phone call, yes, and then after that, I tried to follow up to understand if that was her decision or if this was something outside of her purview.
And when did you decide that this was something you wanted to bring before this court?
After I spoke to my attorney, stating that this was another example of unilateral decision-making.
When? She brought that out on her direct.
What's the purpose of asking the
Well,
question?
I'm just trying to find out how long he sat on his rights before he decided that he wanted to file this contempt motion. He said, if I can speak, he said during his direct examination that he felt the need, that he felt concerned enough to bring this to this court. Ms. Roberts brought that out. I'm just trying to ascertain when.
Overrule the objection, but he cannot be asked about his conversations with his lawyer. That's confidential, privileged communication. You can ask him when he decided to bring it before the court, certainly.
So when did you decide to bring it before the court?
I brought that to my attorney as soon as I had that message.
In June?
Yes,
Okay. And were you under the understanding that it had happened, that she had been enrolled when you got the message in June?
yes,
And this contempt motion, you're aware, was filed August the 19th.
okay.
So why did you not respond and tell Ms. Brooks, I object?
Because none of my prior objections, no matter how detailed or offering of any kind of conversation regarding these decisions, has ever been met with anything receptive whatsoever.
So rather than discuss it with her, you just waited. You knew she was going to do it. And then you waited, and then you waited until the first day that the child was in school, and then you tried to hit her for contempt. Is that right? Is that fair?
No,
It's not fair.
I had informed my attorney and she was going to set the motion for contempt shortly after I was informed that she had enrolled her in the pre-K program.
Okay. So rather than try to resolve it before the child started this program, you waited a couple months.
I did attempt to resolve it before that. It just didn't
Ow.
make it here before that.
How? You didn't tell Miss Wilson that you objected.
I told her that I
You didn't
objected
tell
to.
her that you had this conversation.
I'm sorry, what? All right, let him answer the question before you begin your next question, please.
You didn't tell Miss Wilson that you objected, did you?
There's additional information as to why I made that decision.
Yes or no, sir? Did
No.
you tell Miss Wilson that you objected to this?
No,
Did you tell Miss Wilson that you had had this alleged phone call with Miss Coffinberry?
no, that arrangement was made before we left court during her assignment as guardian ad litem.
What arrangement?
that she would be in touch with us and have phone calls with both of us
I
regarding,
understand, but you testified that you had a phone call with Ms. Coffenberry voicing your objection to this. Is that true?
that was during the discussion of the initial phone call between us, yes.
Okay, did you tell Ms. Wilson that you had had this phone call?
No,
Okay, so you made no effort to tell her that you had any objection to this, right?
on this occasion, yeah.
Okay, and you knew for 2 months and a couple of weeks in advance that this was going to start, right? And you went to counseling, right,
Yes,
where this was discussed.
yes, and I voiced my objection there too.
You did.
I did.
Okay. What did you say?
That I don't agree to it because it's an all-day program. It would be a great shock to our system going from being with family straight into an all-day school program, given that she was having mental health disturbances at the time. Just, it didn't seem like a great idea to me.
Have you familiarized yourself with your parenting plan?
Fairly well, yes.
Okay. Does it say in there that the child shall have the right to attend mandatory school where the mother is teaching?
It does not.
Doesn't say whether it's mandatory or not, does it?
No.
Okay. Is it your contention that your child should be less exposed to education?
Currently, she is exposed to education regardless on my time, and I was not wholly objectionable to a pre-K program, but not an all-day one, where she might have things that come up that set her off.
Well, did you voice this all-day program concern to Ms. Wilson?
No, because previous objections never were received or responded to.
And so you just have decided that talking's not going to work anymore.
Exactly.
So
That's
you'll
why I
just
went
wait
to
and
my
file
attorney
contempt.
after I was notified that she was enrolled. Yes.
Okay. So you went and talked to your attorney right after this June 1st message?
Yes.
Okay. And you're ordered under that parenting plan to pay child support?
Yes.
Okay. And that was through direct deposit, right?
Yes.
Okay. And you didn't pay that child support for the months of August, September, and October, did you?
Unbeknownst to me, no, I did not.
Okay. How much money do you make?
Sorry, repeat the question.
How much money do you make?
Roughly $65,000, $70,000 a year.
Okay. And how much do you normally keep in your bank account?
Right now, it's plenty to cover that.
Okay. And you didn't notice after 3 months that you had an extra $1,300?
No, I did not. My bank account had that padding and then some at the time.
Okay. So why was it not paid?
Because apparently my bank changed billing providers, and that dropped the auto pay from my account. And despite their statements that not despite, their attempts to reach me and inform me of this did not land. So I did not know that it was not carrying over to the new billing.
Did you not keep them apprised of your contact information?
I'm not understanding the
Well, you
question.
said their attempts to contact you did not land.
I don't have any of the emails. The snail mail that they must have sent didn't reach me regarding that. All I have is statements and emails about statements.
So you just wind up with this surplus in your bank account that you didn't notice. You didn't get any snail mail either, you said. No,
Not that stated that, no.
you check your bank account?
Occasionally.
Okay. And you don't notice when that payment comes out for the benefit of your daughter?
Like I said, I've got plenty in there right now, and I haven't had to check it. I haven't had to worry about that amount coming out per month.
Well, it's in support of your daughter, though.
And I thought it was being paid the entire time.
So shifting back to what you allege is contempt, you've already decided that you and Miss Wilson can't talk on decisions, right? That's fair, right?
Fair.
Okay. So then joint decision-making is impossible, right?
Not for lack of my effort.
Well, you didn't make any effort this time, did you?
On this occasion, multiple times prior, though.
Okay. Those are my.
Did you voice your objection? Excuse me, some point in time, did you receive a motion to appoint a guardian ad litem that Ms. Brooks Wilson's attorney had filed?
Yes.
We come to court on that motion.
Yes.
Were you present?
Yes.
Was a guardian ad litem appointed?
Yes.
Were you provided the name and the address?
Yes.
And what was your understanding of what the role that the guardian ad litem would do?
That these decisions that we don't agree on would be made by her.
When you got this notification, did you reach out to the guardian ad litem? When you found out about the daycare, did you reach out to the guardian ad litem?
About the pre-K program, we had a scheduled phone call later than that email correspondence, and I voiced my opinion on it during that.
Did you believe that was the appropriate way that you were supposed to go pursuant to the court saying the guardian ad litem was going to?
That was my understanding, yes, and I tried to verify that.
And then your daughter, prior to that, you and your ex had enrolled your child into counseling.
Yes.
And did you carry your daughter, and did she carry your daughter on occasion to counseling?
To my recollection, she has only had to carry her to that appointment one time. It's been on.
No, it's not, Your Honor. I'll make it relevant. He asked. No.
I'm sorry, what?
Well, Your Honor, if I could respond, he asked him about, did he ever object? My client responded that he objected, and he told the counselor. And I'm expanding on that, his
Overruled.
response. And again, if I could, if I'm not mistaken, this is also his case in chief. So this is my first opportunity to have him also. So I'm not limited by the fact of what cross-examination, because this was direct examination on his motion for contempt from a
You have to
procedural
ask him
standpoint.
about his failure to pay child support according to his motion for contempt, so you are free to question him about those issues as well.
So were y'all present during this, after you received this email saying the child had already been enrolled? Did y'all have counseling sessions after that date?
Yes.
In June, July? Did you
Yes.
voice your objection?
Yes.
Was Ms. Brooks Wilson present in the room?
No, I was having the therapist has individual conversations with both of us and our daughter.
Did the counselor talk to you about issues with Ms. Wilson Brooks?
Yes.
And did you assume, and again, that she was talking to her about the same thing, so y'all could get a resolution about how to deal with your daughter?
She had stated at one point that she would make a suggestion about a resolution.
Okay. Child support. You were divorced in 2020. In 2020, did you establish a direct deposit?
Yes.
And has your child support always been made by direct deposit? When I say always, for the biggest percentage of the time after
Yes.
the divorce was granted, have
Yes.
you paid child support through an automatic debit out of your account and a direct deposit into hers?
Yes.
When did you learn that you had not, that your child support was behind?
And I received the order stating that I was in contempt of court.
Or the motion?
Motion, yes.
And did you, at that point in time, did you bring a cashier's check to my office?
It was I got that on a Friday afternoon, and I was in the bank Monday to get the cashier's check and bring it to your office.
And to your knowledge, was that hand-delivered to our attorney's office?
If so, yes.
So when you learned, whether you would agree that you should have kept up with it?
I do.
Okay. Take responsibility for that.
I do, and I'm willing to accept whatever needs to be done going forward and make that a part of this routine as well.
And we requested, and they provided today, the routing information so you could reestablish that.
Yes.
There's been much question about, did you state any objection or do anything directly to Ms. Wilson Brooks? How many occasions did Mrs. Wilson Brooks contact you and say, hey, I hadn't got the money for Emma Jane?
Never. Never once.
Ever?
Never.
But the minute you found out about it, what did you do?
I initially called you and tried to figure out how to resolve this issue. That was my next, like I said, it was after business hours and there wasn't much I could do except plot. And my plot was to go get a cashier's check and resolve the balance.
And you did that, correct?
Yes.
That's all. Thank you, sir.
Anything further?
She didn't voice her objection about the child support,
It was never stated to me that it wasn't going through anymore.
similar to you not voicing your objection to her enrolling the child in pre-K, right?
That being my first instance of it, yes.
Okay, that was my question.
Anything further, Ms. Roberts? Thank you, sir. You may step down.
Thank you.
I would recall.
Look, if you'll come around, I would remind you to remain under oath.
I neglected to ask you earlier, when was the first time you knew that he objected to you unilaterally enrolling your daughter?
Well, the first time that I heard of an objection was from the teacher.
Okay, and was that before or after the program started?
That was after the program started.
Okay, because again, in your attorney's response, he says that prior to open house, that the school reached out to Mr. Wilson, and in the statement that's filed with the court, that he was rude and said that he didn't object to her, that he objected to her going. Did you read your attorney's response to the motion for contempt?
I did.
Was that a true statement?
Well, open house is the beginning of school, and that was whenever she,
When was open house held?
I honestly cannot remember the exact day.
It was-
Even as a teacher, I cannot remember the exact day that I was there.
Well, but you just said open house was when they started the program, so it was Monday at 8 o'clock?
No, ma'am.
It was
The
on Sunday.
students were not present Monday at 8 o'clock at open house, but the school year had already officially
I didn't
began.
ask when the school year started, I said when the program started.
Well, the program starts with the school year, so I'm not sure exactly which date you would like for me to tell you.
So they have open house during regular hours, Monday through Friday. It wasn't the Sunday before,
We don't have school, we don't have any events on Sunday nights.
or no Saturday, it was during the week,
Yes, ma'am.
and your daughter wasn't there.
She was not there, so I do know, I can say teacher, open house is a teacher in-service day. So on that in-service day, we're required to call all the parents.
So it was an
Kinda greet
in-service day,
ourselves.
so the program had not started.
Technically, the program did start. My child did not start that exact same day.
The program starts on an in-service day?
The pre-K program in any school year starts on a particular day, but students did not attend that day. So the school year had officially started, but students were not attending that day.
Open house is, you just said was on a in-service day.
Yes, ma'am, on a Monday, on an in-service day. Actually, I think open house might have been on a Tuesday. I think Monday was our in-service day, and then open house was on a Tuesday.
And so that was the guardian ad litem in June and July, and speaking to you, never advised you that he objected to going.
No, ma'am, never advised me that he
And so
objected.
when did you understand that he had said that I guess he had to defer to the guardian ad litem?
His response to my email was that it was up to the guardian ad litem.
That's all. Thank you, ma'am.
Right?
At the time of this open house, you had an email from the guardian ad litem that says, "In so much as he has deferred to me, I support her enrollment in the pre-K program." She opened the door to what was said. I'm actually offering this for the proof of the effect on the listener and not the truth of the matter asserted, honestly. She definitely opened the door to it then.
Well, it's pretty clear from what has been said already that what the guardian ad litem's position is, but in any event, we'll overrule the objection and allow it to be brought in for the purpose of showing why she took any action or did not take any action.
Again, were you privy to that email at the time of the open house?
Yes.
Okay.
Are you referring to the email that,
This is
Did
a
you-
parent decision, but in as much as he has deferred to me, I support her enrollment in the
Yes,
pre-K
sir.
program. Did you intentionally violate any court order?
no, I did not intentionally violate any court
Do
order.
you believe that you did violate a court order based on the way the parenting plan is written?
No, based on the way the parenting plan is written, I don't believe that I violated anything.
Do you believe that Emma Jane has a right vested within that parenting plan to go to school where you work?
I do believe that she has a right.
Does that right distinguish between mandatory and non-mandatory school?
It does not distinguish between that.
Roberts, any other questions?
Again, I withdrew my objection on that. The email from Ms. Cothenberry reiterates to you, and I don't know let's see the date of that. She said, this is a parent decision. You'd like to see the response that
No, ma'am.
isn't that what Ms. Cothenberry said, that it's not her decision, it's a parent decision?
Yes, ma'am.
When did you know you weren't getting child support?
I believe I noticed, kind of toward the end of August.
And how many months did you go without it?
August, September, and then October.
Did you call up or send message to Mr. Wilson to say, hey, what's up? Why aren't you paying child support?
No, sir, I did not.
You want me to put him in jail for not paying child support?
I don't believe he deserves jail time for not paying child support.
All right, step down. You have any other proof, Mr. Spratt? Hearing argument.
This is one of those matters that I know Your Honor gets aggravated at in a lot of, among other things. But again, this is just the whole predicament. I don't know if Your Honor remembers this case back in 2020, but this is the exact same behavior that was going on. These people do not communicate with one another. Ours is a very narrow issue, not whether the pre-K is a good program, not whether the child will benefit from it, not where she's going or what she's doing. The parties are to make right now joint decisions about their child. It is undisputed that Ms. Brooks Wilson sent him an email, unilaterally enrolled this child in an educational program without discussing it with him. Now, again, no disrespect to my client, did he just, should he have picked up the phone and called and said, hey, let's talk about this, and I really don't want her, is there a half-a-day program, is there somewhere where we can do it, that she can go the whole time where I'm not involved, I'm not missing my days, or we slowly integrate it? Yeah, maybe he should have been the bigger person to do that, but he wasn't. But she should have been the bigger person and followed the court order.
I agree, they both should be bigger people.
Exactly. That they're so still got their feelings hurt, and that they are not cooperating as it relates to this child. But again, it's a very narrow issue. Did she consult with him and make a joint decision about this educational program? No, she didn't, period. Now, again, no good deed goes unpunished, and karma can be a wicked master, in the fact that we brought this to the court's attention, and in attention of both parties' part, for some way, it wasn't that he stopped paying child support. He was inattentive about it. He had it set up through automatic debit. However, for whatever reason, that got stopped. Did she pick up the phone and call him and say, hey, where's my child support? No, she didn't. She didn't notice it, according to her testimony, and neither did he. But the difference is the minute that he found it out, he corrected it. Now, would a conversation between these two parties stopped all of this? Absolutely. Absolutely it would have. A simple, civil matter of picking up a phone calling, and not worrying about who makes it. She should call me, he should call her. But the fact is we have very rigid court orders that need to be followed, and possibly neither one of them did in this case. And so I think the stern attention of the court needs to be directed at both of these parties. Because this child, Miss Emma Jane, it's already been put in. My client reached out and said she needed to go to counseling. They asked for a guardian ad litem to be involved in this case, so obviously it's affecting that child.
Unless you've got two, how many sets of handcuffs do you have? You just have one? Can you get another one? Oh, you have two. Okay, good.
Well, on that respect, as long as myself or Mr. Spratt aren't involved in it, I hope neither one of our clients are. It's a criminal contempt matter. You can't correct either of these things. My client paid the child support, but did he miss 3 payments? He did. Was it willful? No. Could she have picked up the phone and called and discussed it rather than unilaterally doing it? She is already enrolled. It is what it is, Your Honor. So, again, this is one of those nitpicky things, and I just leave it to Your Honor's
This child
discretion.
is almost 5 years old and will
She'll
be
be-
5 in December.
Mhm.
What's the age mandatorily for the child to attend pre-K or kindergarten?
In the state of Tennessee, I believe they've changed it. I think they have to be 5 years old as of September. I think it is August, the end of August.
So the point of that is
It
that,
used to be the end of July, and then they moved it, and I think it's at the end of August.
so the
It's-
point is
It's
that
the end of August.
this coming school year, the next school year,
She
this child
goes
will
to
be
school.
mandatorily required to be in school.
She will.
Right.
She will.
Mr. Spratt.
Surprised the court, I agree with a lot of what Mr. Roberts just said.
You do know this is being recorded.
I do. I do. Also, well, I'll get to that later. I have her umbrella we were talking about yesterday, but there's obviously a lack of communication here.
That is one of the most unnecessary statements
Yes,
that you
sir.
can make in this particular case.
Yes, sir. But, you know, to address the standards, we've both elected criminal contempt here, which
I'm
brings
going to
reason-
address the standards, but you go ahead.
which brings reasonable doubt into play. I don't believe that either party has proven that either one of these, that the other has willfully violated a court order beyond a reasonable doubt. I will address the language in the parenting plan in that, you know, Mr. Wilson could have been well-founded in believing that the guardian ad litem made this decision. The parenting plan says that it vests that child with a right. So in so much as it says that, she has a guardian ad litem. Guardian ad litem's input on the decision came out in the hearing here. It seems to me, there's proof in the record that if he chooses not to take the child to the pre-K program, they're not going to remove the child. So it's not interfering with his parenting time. And the order just doesn't, there's just no way that she directly violated a court order. And it would seem from the proof that probably Mr. Wilson didn't either with the child support. So it's a matter of, it's just a matter of
Whose
communication.
responsibility is it to ensure that they pay child support? The mother or the father?
Well, it's
If the obligor or the obligee?
it's his responsibility to pay his
Exactly.
child
It's
support.
his responsibility to ensure that the child support's paid.
It is, Your Honor. And I asked if he checked that. And
And I make that point because clearly you can say that the automatic draft didn't go through, so, you know, it's not not his fault, but it is his responsibility. It's your client's responsibility to ensure that she complies with the court order.
It is.
So arguably, you could say they are both in violation of the court's orders. Him by not paying child support, it's his responsibility. Her by not adhering to the very letter of the law, and a child in that. And so it's an intentional violation of a known duty. Statutory definition of intentional conduct is found in the Tennessee Code. Intentional refers to a person who acts intentionally with respect to the nature of that conduct or to a result of the conduct when it's the person's conscious objective or desire to engage in the conduct or cause the result. To satisfy the culpable state of mind requirement, the act must be undertaken for a bad purpose. In other words, willful disobedience in the criminal contempt context is conduct done voluntarily and intentionally with a specific intent to do something the law forbids. This parenting plan that we're dealing with in regards to the motion for contempt brought by Mr. Wilson specifically says that the parties will have joint decision. What it actually says is major decisions regarding each child shall be made as follows. Educational decisions, joint. Non-emergency health care, joint. Religious upbringing, joint. Extracurricular activities, joint. In reference to this, an educational decision would be enrolling the child in pre-K when it's not required mandatorily. The interesting question will be when it's a mandatorily required, and this does provide that the child shall have the right to attend the school where the mother is teaching, but this shall not in any way impact the requirements of the parental relocation statute. So when this child gets ready to attend the school in the fall, which is mandatorily required, is that an educational decision that she has to consult him in when the plan provides that the child shall have the right to attend the school where she teaches? Or does she have to call him up and say, I'm going to enroll the child in the school where I teach, when it's already provided in that? So there's a somewhat of a conflict in the language of it, and as pointed out by Mr. Spratt, nowhere does it say that it is only mandatory school attendance that is required for that. More importantly is that Mr. Wilson had an opportunity to object prior to, according to testimony, she notified him that she had enrolled the child 2 months before the beginning of the program, and he did not object to it. Should she have consulted him? Yes, absolutely she should have. Should he have objected within that 2-month period? Absolutely should have. So the problem is that they're both, again, failing to act in the best interest of the child because they apparently hate each other so much. I can only imagine what this child is going to grow up with for a future. Child that's not quite 5 years old has got at least, what does that make it, another 7 years to have to live in a situation where two parents feel this way about each other. He didn't pay the child support according to the court order, but it's not willful on his part. He thought he had it set up to where it would do it. Should she have called him and said, hey, I didn't get the child support deposited by automatic draft, and what's going on? That would have alerted him to it. So it could have been done better on both of their parts. But under the language that I've just quoted in this court's opinion, I cannot find that Mrs. Wilson was beyond a reasonable doubt intending to voluntarily and intentionally with a specific intent to violate this court order guilty of willful contempt. Neither can I find that Mr. Wilson specifically and intentionally, voluntarily, and with specific intent violated the law regarding payment of child support. Neither of them is in contempt. But they've both had their say in court about how bad they think the other one is. So I hope that you feel refreshed and like you've had your day in court, and that you feel better about yourself for having been able to come into court and argue about this. I've given you that opportunity. The sad part is that none of this benefits your child. Not one thing that was said today benefits your child, in my opinion. Henceforth, you've got a pending motion to modify it. I understand Mr. Wilson's objection, because enrolling the child in a day-long daycare is going to, with the schedule that he has, is going to directly affect his ability to exercise that schedule. So I understand why he would have an objection to it. But again, he should have objected to it, and he should have made it known as soon as it was made known. Just like he made a doctor's appointment without consulting her prior to making that doctor's appointment. Is that an educational decision that he should have, made before that? According to what the proof is, he notified you right away. There was no objection voiced. But point of the fact is that there's a common sense application to be made in these situations. Hopefully we'll be able to resolve this, because there's a petition to modify the visitation schedule that's going to be going down, or going to have to be heard while this case, before the child maybe starts school in the fall. But in the fall of school, this coming fall school year, the child will be mandatorily required to attend, so it's going to have to be dealt with at that point. In any event, I don't find either one of them in willful and deliberate and criminal contempt beyond a reasonable doubt. I hope that they can learn from this exercise and perhaps avoid these kinds of issues by communicating. But I've said that to them before. Ms. Roberts is right. All it would have taken was for her to pick up the phone before enrolling the child and say, hey, I can pick up a phone and say, tomorrow I would like to enroll this child in this program. If you agree with it, we can do that. If you don't agree with it, I'd like to go ahead and enroll the child, and then you don't have to take the child on your days if you don't want to. That would have solved the problem. She should have picked up the phone and said, hey, your child support's not being paid. He should have objected to the schedule that she wanted to apply. One of you is just as guilty of doing something that's not, that would have avoided, you could have done something that would have avoided this as the other one. So under those circumstances, I do not find there to be any basis for a finding of criminal contempt, and therefore both of these motions are respectfully denied. Now, maybe I misunderstood, so. Well, that is what they should have done in that case. But I'm simply saying that there's not, in my opinion, a willful, deliberate contempt about it, and for that reason, I find that there's no reason to make either one of them in contempt and impose any sanctions.
Hey, thanks for watching. If you enjoyed that video, do please take a moment to like, subscribe, and leave a comment on the video. We'd really appreciate that. And if you want to keep the fun going, check out the video on the screen right now.